I'm David Lombardo, and you're listening to WCNY's The Capitol Press Room. In order to address so-called ghost jobs, employment opportunities that might get posted but aren't really being filled, Democratic state lawmakers pushed through new disclosure requirements for large employers when they advertise a job vacancy. For more on this measure, we're joined remotely by Jared Cook, senior counsel at the law firm of Tully Rinckey. Well, I have to admit, it's about 7+ years since I've looked for a job, so I'm not familiar with this problem that the legislature is looking to address. So can you talk a little bit about this problem of so-called ghost jobs and how the Democratic lawmakers are looking to address it with more disclosure from large employers?
Yeah, I mean, admittedly, it's not something that I've seen a lot of in my practice, but one of the findings that they made as their justification for this bill was the fact that there are a lot of job advertisements out there that are for jobs that aren't being filled. They mentioned something like 40% of the postings on there were for jobs that didn't actually exist. Either it was a job that had already been filled, or it was something an employer was just sort of, collecting resumes for something that might come up in the future. And the thought process, as the sponsors of the bill have explained it, is, if you're trying to find a job, you don't want to be spinning your wheels, sending in resumes and applications for jobs that don't actually exist. So the idea is to try to make it a little more transparent for people who are looking for jobs so that they can focus on the jobs that are actually being hired for.
Well, yeah, can you talk about the disclosure requirement that would apply to private
Yeah,
companies with at least 100 employees that are looking to actually fill a job and not just collect resumes, which is something I didn't
right.
even know I could do as an employer?
Right. Well, and you still can do that. The law doesn't say you can't. It just means you just have to disclose that that's what you're doing. So there's kind of three tiers that the law sets up. First, it says that if they intend to fill the job within 90 days, then they have to say, this is a current vacancy and the employer expects to fill the vacancy by such and such date. Second tier is if you expect to fill the job, but not for 90 days of the time that you put it up. Then it'll say you have to disclose this is a current vacancy and the employer expects to fill this job no sooner than whatever date it is that you expect to fill it. And then the third tier is if it's not a currently open vacancy. And then you have to disclose this is not a current vacancy, but the employer is seeking to review resumes for the future in case any vacancy opens up.
Well, what's your understanding of wiggle room in this measure if, for example, life happens and maybe you were planning on
Yeah,
filling a job after 90 days, but that right candidate
yeah,
walks in the door and you want to
right,
lock them up? Does this proposal offer any sort of wiggle room for that? Or do you have to say to that
right.
prospective employee, hey, I'd love you to start tomorrow, but unfortunately, I can't even announce that we're hiring you until X amount of time?
The text of the bill, it doesn't really nail it down and say, you absolutely must comply with this expectation. It frames it in terms of expectations. What does the employer expect to do? Um, and there's when you get into the enforcement provisions, it says that first of all, the DOL can audit to make sure there's compliance and that the DOL can issue a fine of $2,500 for each violation in the advertisement. But it doesn't say anything about, it's still framed in terms of expectations. What does the employer expect to do? But I don't see anything in the bill that says that, if you say that this is your expectation, then you absolutely must follow that or else get fined. The law does also give authority to the DOL to make regulations, which is pretty common with a lot of employment legislation, that the DOL has the authority to make regulations to fill in gaps, to answer questions that may be left unanswered by the law itself. So we may see some new regulations from the DOL about trying to define the line between the right candidate walked in and we decided to make a spot for him, or does this look like somebody that's really just trying to evade the law?
Well, that sort of nuanced approach that you laid out there is something the assembly sponsor of this bill talked about when he said during questioning that he assumed the State Department of Labor would take kind of a holistic approach to monitoring this issue. But I was curious how you saw this playing out in terms of a violation even being highlighted. Is this something where you envision a job seeker is going to look for a job, run into one where maybe it's not being filled or there's not the disclosure, and then they report it to the Department of Labor? Because that seems to assume that your average job seeker is going to have to know about this provision in
Right.
state law. Otherwise, it seems like it's up to the State Department of Labor to police it because they're probably the only
Right.
ones besides you, me, and your, buddies at the attorney employee conferences who are going to know about this.
Sure. Yeah, no, you're right. The average person, unless they happen to hear your brilliant reporting on this or something,
Fingers
they're
crossed.
not going to be aware of this, right? They're not going to be looking for it, and that's I think that's probably why the law frames it in terms of an audit by the DOL. That the DOL is commissioned with responsibility to go out and audit compliance. Now, that said, nothing would prevent somebody if they saw a job advertisement out there that they think is non-compliant. Nothing would prevent them from calling the Department of Labor, reporting it. They can investigate it. But I don't get the sense that that is the primary way this law is envisioned to be enforced.
Well, before we move on, let me reintroduce you for listeners just joining us. This is WCNY's The Capitol Press Room. I'm David Lombardo, and we're speaking with Jared Cook, senior counsel at the law firm of Tully Rinckey. Well, with the time we have left, I want to turn to another bill that Democratic lawmakers pushed through the legislature this year, and that has to do with the amount of time that New Yorkers have to evaluate a severance agreement before they approve it. Essentially, this idea that if you're given a short window of time to evaluate a severance package, that it's essentially akin to getting an ultimatum. Maybe you're being coerced into signing it because of how little time you have to evaluate it. What sort of calendar would be laid out for employees moving forward if this measure does become law?
Yeah. So this is another one that has passed both the Senate and the Assembly. Assuming Governor Hochul signs it, it will become a law. The timeline is, well, there's three things that the employer has to notify the employee. Number one, they have to tell them that they have the right to consult an attorney before signing the severance agreement. Number two, they have to give them 21 days to consider the severance the severance agreement. And then after they sign it within those 21 days, they have to give them an additional 7 days to decide whether to revoke their signature or not. So you get 21 days, you get 3 weeks to decide whether you want to sign it, and then you get a week during which you can change your mind, basically. This is not a new idea. It didn't come out of nowhere. This is already federal law with respect to certain laws. The Federal Age Discrimination and Employment Act provides that the prohibition against age discrimination is not something that can be waived. So you can't waive a claim under the ADEA unless the waiver that's presented to you, you've had 21 days in which to consider it, and then you have an additional 7 days to decide whether to change your mind.
What is the age discrimination component of evaluating a severance agreement?
Yeah, no, that's a great question, and that's we should probably back up a little bit. So most of the time, you get a severance agreement proposed by an employer. The employer is giving you severance. They're asking for a waiver of claims. So essentially, what this means is, you're going to give me, whatever number of weeks of severance it is you're going to give me, and in return for getting that severance, I agree to waive any claim that I might have against my employer for discrimination, and really it's any claim. It could be any kind of discrimination. It could be sexual harassment, whatever. It could be wage claims, whatever it is. We are essentially buying each other peace of mind. You are buying me off by giving me this severance. That's going to help me transition into my next job, whatever it is. And in return, I'm giving you peace of mind that I'm not going to come after you and sue you for something that happened while I've been working for you. So when you get a severance package that asks you to waive any claims, including age discrimination claims, then that's when these provisions under federal law kick in, and they have to give you the 21 days and the 7 days to change your mind. So what this bill does is essentially takes that and it makes it apply to any severance package in New York, regardless of whether they're specifically asking you to give up age discrimination claims or not. Most larger employers, when they give an employee a severance agreement, they already have the age discrimination language in there. And so they're already following this. Smaller employers that maybe don't necessarily have a standard severance agreement, they're going to need to be aware of this, and they're going to need to maybe change some of their practices.
Well, is the big practical change this idea that anyone under the age of 40 is now going to be insured these provisions here in New York? Because my understanding is that under the federal timelines, that only applies to people over the age of 40, a cohort that I am not currently
Yes.
part of.
Right. No, that is correct. That's right. So a lot of employers will go ahead and just throw the same standard language in whether you are over 40 or not, just because it's administratively easier just to say, this is our standard practice, this is what we do. And there are some other states that already have this as part of their state law as well. So as an employer, it often makes sense to say, we're just going to pick the most restrictive law, make sure that we're complying with that, and then we don't have to worry about any other states. But employers that do kind of, go state by state or employee by employee and decide, do we need to comply with this or not? Yeah, they're going to need to be aware of this.
Well, unfortunately, that's all the time we have for this conversation. We've been speaking with Jared Cook. He's a senior counsel at the law firm of Tully Rinckey. Jared, thank you so much for making the time. I really appreciate it.
Thank you. Very, very happy to be here.
Support for the Capitol Press Room comes from O'Donnell and Associates, a public affairs firm providing strategic guidance to businesses and nonprofits on navigating policy and regulatory issues. More information is available at o'donnellsolutions.com.